Hello, and thank you for joining us today for the latest in our LexisNexis Legal Talk series. My name's Michael Contudis, and I'm a legal writer for Practical Guidance Dispute Resolution. Today, we'll be bringing you a discussion about tips and traps when preparing evidence in litigation. And I'm very privileged to be in a position to say that joining me today to share her insight and practical experience is Jodie Walcombe, a partner at Thompson Geer in Sydney. Jodie has extensive experience in commercial disputes across diverse industry sectors, including resources, manufacturing, medical, financial services, media, and technology. Practicing in state and federal jurisdictions, Jodie's experience includes complex litigation cases involving matters of contract interpretation, shareholder disputes, and breach of duty. Jodie is also an advisor for our Practical Guidance Dispute Resolution module, and also an author for a number of topics in that module, including our New South Wales Supreme Court topic, our Federal Court topic, and very recently, our Evidence, Practical Issues in Litigation subtopic. Welcome, Jodie. How are you?
Thank you, Michael. I'm well, and I'm happy to be here talking with you today.
No, it is definitely our pleasure. So, Jodie, in light of that sort of rundown of your experience and expertise that I just gave, I'm really excited to be speaking to you today about preparing evidence in a practical way. We're going to be discussing tips, tricks, traps that lawyers, solicitors and counsel often fall into when preparing evidence, and also recent cases that shed light on those points. So to get the ball rolling and to sort of give a bit of a pretext for the discussion, I can speak from personal experience about when I learned the critical importance of evidence. And this was drilled into me very early on in my career as a litigator. I remember I was in my articles year, as it then was, working with an experienced King's Counsel on a big Supreme Court case. And we were deep into trial preparation in his chambers, and I was leafing my way through the law reports and browsing Casebase, looking at cases, trying to pull out helpful, precedents, and doing my research when this King's Counsel turned to me very seriously, glared at me and said, "Michael, what you're doing is very, very helpful, but never, ever forget it's facts that win cases and not the law." And that's stuck with me ever since. Would you agree with that sentiment, Jodie?
I would say that is generally true, and I have a similar story of being a junior lawyer and having a senior counsel explain to me in quite detailed way the importance of the chronological bundle of the court book, and that, whilst it might seem like a administrative task that I was doing, that it was of critical importance to the conduct of the hearing and the smooth conduct of the hearing. And similarly to your story, that stuck with me ever since. And as a litigator, fact-heavy cases are often my favourite, if you can say that, because part of what I really enjoy in the role is putting the pieces of the puzzle together. So you might have one side from your client, but then you might get documents under subpoena or under a discovery process, and it's piecing all of those bits of the puzzle together to create, a really powerful story or set of materials. And sometimes that can be just as powerful as the smoking gun, as they say, which, in my experience, it's very rare to find the smoking gun, but sometimes having that really well prepared and put together bundle can be just as powerful. And one of the tools that I commonly use, and I know a lot of other practitioners use to help that, are things like chronologies, evidence matrices, so that you can see where the gaps are, where you might need to make some more investigations, either from your client or a third party or the opposing party. But it makes the evidence, I think, more digestible and helps to tie everything together.
Yes, yeah, I definitely agree with that, Jody. I mean, at the end of the day, the evidence is telling a story, a particular story, and if you can make it digestible and easy to follow, that's always going to hold you in good sway before a judge who's trying to follow and make sense of what has actually happened. So if we accept then that we agree that the evidence is critically important, its proper preparation is equally critically important. And that being the case, what advice would you give to practitioners acting in new matters that are likely to involve, a significant number of witnesses at trial? What should that practitioner be doing or thinking about from the earliest stages?
So there's probably three main things that I would say in response to that question. I think it's a really good question. And I think that the more thinking you do about these things at an early stage, the better for the conduct of the matter. But the critical question is this evidence relevant? Does this evidence serve a useful purpose in this case? And if you can't answer to the affirmative to that question, then you really need to question why you're putting that evidence in. And particularly in these days where principles of case management are becoming more and more prominent, to be able to justify the number of witnesses that you have in the case, the amount of documents that you want to rely on, you really need to be able to, hand on heart, say that those things have some relevance. And sometimes that can be difficult at the start of a proceeding, and that is why making these investigations at an early stage can help to make those calls early on. So that would be the main point. Why am I putting this statement in an affidavit? Why do I think that this document should form part of the case? The next is probably more of a practical thing, but just being really organised. Witnesses are often time poor. Preparing an affidavit with you might be the last thing that they really want to do. And the more that you can aid in that process, the better. And that is things like having witness bundles prepared and provided to the witnesses in advance, having an outline of what you want to ask them, telling them in advance what investigations they might want to make. So have they checked their email inbox? Did they have a diary at that time? Do they have a habit of taking notes so that they can take those steps before you meet, rather than sort of raising them during the meeting and then having them to go off to do those things? And I think it sends a signal that you're on top of the material, and it allows you to then ask the right questions of that witness. So that's a practical thing then, particularly when there's lots of witnesses. That's a really key point to make there. And then thirdly, when you actually get to the stage of drafting, one thing that I really I feel very strongly about is using the witness's voice in an affidavit. There is nothing more obvious to the court than when a witness comes to give evidence in court and their appearance and the manner in which they speak is unrecognisable compared to the tone or the content of their affidavit. And it really, I think, creates then a inference or an impression that the evidence might not be their own. So it's a really important thing that I think about when I'm preparing affidavits. I ask the witness if they're comfortable using particular words. What would be the word, or how would they describe a particular thing if they were doing it as part of their everyday life? Sometimes that involves them role-playing a conversation with me so that, I can authentically capture what they say may have been said during that conversation. And I think that that's a really, good way to not so much protect your witnesses, but ensure that their evidence is actually being given in a form that is consistent with what their instructions are. So I think that's a really important one in that respect. So I suppose they're my three main tips when there are a lot of witnesses and you're at that evidence preparation stage.
Yeah, thank you, Jody. I agree with all of those, and particularly, there's nothing worse than having a witness in the box under cross-examination, and they are asked why they used a particular word or phrase, and the response, the dreaded response that, well, my lawyer drafted that. There's nothing worse. So absolutely,
That's
and sort of
correct.
that neatly, yeah.
And another sort of common one of those is where there's the use of definitions. And so particularly in cases where, for example, there might be a number of entities in a group, or a particular place or event is defined in a manner that then if it's used later in the affidavit but not in the correct context, that can also trip witnesses up. So that would be another little trap, I would say.
Well, that leads me neatly into my next question about common difficulties and traps that lawyers encounter or fall into when they're preparing evidence for trial. And we've sort of just, given lip service to some of the common pratfalls that you might encounter, but surely there are others.
Yeah, so I recently was involved in a case heard in the Supreme Court of New South Wales, where the particular difficulty for my client was that it really had not been in control of the entity whose records were relevant to the proceeding during the period of time where some of the conduct relevant to the matter had occurred. And so it was an interesting case where usually you would say contemporaneous business records, for example, are the most reliable records or evidence of events that occurred. But in that case, the reliability of the business records was completely an issue and in question. And in that respect, it was quite difficult because you couldn't make the assumptions or inferences that you perhaps could usually rely on in preparing evidence. And one of the interesting consequences of that was raised in this case and discussed in the judgment is how that can then affect the onus of proof. Because if the counterparty or opposing party perhaps had control of the materials at that time, whether then some of the evidentiary onuses can shift to them in those circumstances. So I think that was a really interesting one because it was a bit out of the usual context where you do heavily rely on contemporaneous records, which are usually described as being, the best evidence of an event. So one of the difficulties might be where you can't or you don't have that documentary evidence to rely on, and then it's looking at, well, what are the other surrounding circumstances or other evidence that you can draw on to persuade the court to perhaps draw an inference about particular issues. What other investigations can you do to see if somebody else perhaps might have records, so a bank or another company in the group? So that was a really interesting, I think, highlighting the difficulty perhaps of where you don't have reliable records to rely on in preparing your evidence. I think the other thing might be sometimes in an attempt to perhaps give too much context or flavour to the evidence, that you fall into the territory of really putting in things that are more in the nature of submission or, really are not relevant. And again, leading into the sort of case management principles that I referred to earlier, you're not going to get a lot of sympathy if much of the evidence is ultimately not relevant. And again, that could then lead to cost consequences. So I think that it's really important to, feeding back into what I was saying before about relevance, making sure that you have a good reason for putting in any evidence that you do. So they're probably some of the difficulties. Obviously, sometimes a difficulty might be time, that you're dealing with events that may have happened some time ago. I often say that, most of us probably can't recall a conversation we had last week, let alone a number of years ago. But that, often you will have a real sense of what that that discussion was about, or perhaps, a note. So it's seeing what records that you have to help you refresh your memory so that as best as you can, that you can give evidence of something that might have happened some time ago.
Yeah, thank you, Jody. That happens all the time, unfortunately, and I mean, similarly to instances where there's very little reliable documentary evidence. Often you find that either in the early stages or even when a trial is fast approaching, you don't have the lay evidence. The witnesses are not available to give evidence, for example, which can be a nightmare scenario. And can you give any sort of guidance or advice for what to do or how to tackle a scenario where that happens?
Yeah, I think early in a case, you probably will get at least a sense if a witness might not be cooperative. And that is because perhaps it's a former employee, so they're no longer employed by your client, and perhaps are not able to give the same attention to it as if they were an employee. It may be that the person can't be located, and in which case then you have to think about, is there another way that I can get that evidence? And if you form a view that there's not, then considering what steps you might need to take to be able to deal with that potential that either the witness becomes uncooperative or you can't find them. So one of the things you can do, that if there is a witness who's being helpful, but then you have perhaps a sense that might not continue, you might want to consider whether a subpoena to give evidence is necessary. And that can be done in a way that is not a confrontational way. And sometimes witnesses who are not, for example, an employee may want one, because it then gives them, a court order that they can tell their current employee that, well, I'm, actually required by this order to be in court. It gives them a basis to claim their reasonable expenses of attendance at the hearing. The other is that if the maker, if you have some evidence of a prior representation, for example, but the maker of that statement is no longer available under the definitions, for example, in the Evidence Act, if there are steps that you can take to try and get that evidence admitted in an admissible form. And I recently had an example of that, again, in another Supreme Court case where an individual had provided some evidence that was helpful in that case, and we had to comply with the notice and regime under the Evidence Act for where we said the maker of the statement was not available. And that was the first time in my over 17-year career that I'd had to go through that process. But it was a good learning experience for me to see what you actually had to do to comply with that regime in terms of the notice that you give, the response that comes, and the key issue in that debate is around whether or not the steps that you took to perhaps locate that witness if they are alive, or in other scenarios that you took all reasonable steps to either locate the witness or get that evidence in some other way. And that decision had some quite interesting discussion of the principles around those, and obviously a lot of the times they'll be heavily fact specific, but it did have some good guidance about that, and it might not be an issue that comes up all the time or very often, but it is useful to be aware of the process that you can follow if you're trying to get evidence in that the witness is not available, and otherwise it would be inadmissible because it was hearsay. So I think that is a good example of where a step that you can perhaps take even if the witness is not available.
Yeah, thank you, Jody. And that sounds like an interesting case to be involved in. I suppose in a similar vein, there may be circumstances where you have a witness who is available but not available to, say, travel interstate or overseas to give evidence, or it might be inconvenient for them to do so. So personally, I've noticed and observed an increase in the willingness of courts to permit witnesses in those circumstances to give evidence remotely by video link. Of course, that seems to be spurred on over the last couple of years of the pandemic, that shift. But heading now into late 2022, when we're recording this, my sense of things is that the court's attitude may be shifting now that we've all transitioned to what might be called living with COVID-19. So, I mean, just the other day I was reading a recent decision of the Federal Court in the New South Wales Registry in the Zonia Holdings and Commonwealth Bank class action. So this was an interlocutory decision by Justice Yates, who had to determine an application by CBA, who was seeking an order for permission for one of its witnesses to give evidence by video link under, I think it's section 47A1 of the Federal Court Act. So that witness, from memory, was a non-executive director based in the UK, had plans to travel to give evidence in person at the trial, ultimately couldn't due to some change in circumstances. And the court in that case, Justice Yates, found that the witness's evidence was of such real forensic value and really addressed matters of real significance to the dispute, such that, the evidence really had to be tested in person, he found. And I've got here a quote from a passage in Justice Yates' decision, which I might just read for the benefit of all of us and listeners. So Justice Yates remarked, "While it might be technically possible for the witness's oral evidence to be taken by video link, it does not follow, of course, that adopting that means of taking evidence is appropriate or provides a satisfactory alternative in the current circumstances to him giving evidence in person. My own experience as a trial judge in complex commercial litigation leads me to suspect that, for a number of reasons, taking the witness's oral evidence by video link might well be markedly inferior to taking that evidence in person. I am not prepared to expose the applicants, or indeed myself, sitting as the court, to that risk." So, having regard to comments like that by His Honour, Jody, what is your experience with witnesses giving evidence by video link? And have you personally noticed, anecdotally, any shifts in the court's attitude towards giving evidence remotely in that way?
Yeah, I thought that case was actually really interesting, and it didn't really reveal the reason why the witness was saying that it was no longer convenient for him to travel to Australia. And I think in those circumstances that was quite revealing. But I've done many cases over video link now. In cases where the whole trial is over video link, or somewhere the parties were in the courtroom but particular witnesses were giving evidence on video link. And personally, I probably share Justice Yates's view that my preference would be for everything to be done in person. I think that it's quite difficult at times to create the same environment of the courtroom when it's being done on a over the video link. Obviously, the witness is often at home, or even if in an office, it's not quite the same as when you're there in the courtroom. And I had a quite a nightmare experience, I'd say, where a trial was being conducted over the video link, and after an hour of very effective cross-examination, we were informed by the court reporter that they were concerned that the transcript hadn't properly recorded the evidence. And we had to then very anxious wait while the court reporter went back and reviewed the recording to see whether they could actually transcribe it. And luckily in that case, it turned out okay. But you can imagine the idea of trying to repeat that evidence when the witness knew what was coming would have been less than ideal. So in saying that, there are certainly cases where I believe having the flexibility to give evidence by video link is very useful, and that is where a witness physically cannot travel because of illness, for example, or as we've experienced with COVID, because the particular country that they're in have restricted travel because of cost. That it might be unfair to require a witness to bring, a party to bring a witness across the world with the expense that travel costs these days to give evidence for a short period of time. And so I think we are shifting back to the sort of pre-COVID balancing exercise that applications for evidence by video link sort of undertook. And I think that it's really going to depend on the particular case, the reason why the witness can't travel, the importance of that witness to the case, whether there are a lot of documents. Obviously, cross-examining a witness where it's a very heavy documentary case can be very difficult if they're not physically in the same courtroom. And it's really going to be that sort of balancing exercise. The exception probably being if both parties consent. I think it would be much more unlikely for the court to not grant that leave if it's by consent of both parties. And I think that one change is that you do more often get consent if you can justify why the request is being made. So that would be a change that I've certainly noticed.
Yeah, it really does look like it will depend on the particular circumstances. But it seems to me that the shift has been that the preference is always for evidence to be tested and given in person, rather, and the mere fact that it might be more convenient will no longer really cut the mustard in terms of getting leave to give evidence by video link, which I can certainly see the logic behind it. So look. Thank you, Jody. I know you're busy at this time of year. I'm reluctant to take up too much more of your time. This has been an excellent discussion, and I'm sure everyone would agree who's listening that your insights have been illuminating. They have been for me. And look, I expected that because I have read and published our new evidence subtopic that you've authored for our practical guidance dispute resolution module, which is live now, and it's full of similar insight and expertise. Packed into all of our new guidance notes, checklists, and precedents that you've created for us. So, Jody, thank you very much for joining me and for participating in our LexisNexis Legal Talk series.
My pleasure. Thank you, Michael, for having me.